Good morning.
Good morning, my lords. It is thankfully cooler in here this morning, but your clerk kindly indicated that we continue to dispense with fancy dress. I'm grateful. My lord, to start off with some good news. My learned friend and I had a helpful exchange after court yesterday. If I could just ask you please to turn to the judgment at paragraph 232. And my learned friend has indicated that he is no longer relying on little b at the end of 232. So as far as he's concerned, everything now turns on having sufficient efficacy to treat diabetes. And for that reason, the tool point has fallen away, and so I don't need to pursue the respondent's notice.
Thank you. Thank you both.
The next housekeeping point, my lords, the date of hand-down and delivery to the parties and publication of decision T314 of 20 is the 20th of December 2024, which my Lord Justice Arnold asked about. And the other point arising from this is Mr. Romandini is the legally qualified member of the board, which makes his involvement in both decisions perhaps more intriguing, but
I was aware of that.
I'm grateful.
Can I just ask while I remember, are you receiving overnight transcripts?
My Lord, yes, we did receive them.
Right. Could they be shared with the court?
Of course, I'm sorry.
It doesn't matter.
I think I've had.
Have you had them?
Yes, I think so.
Right.
Maybe I've been privileged.
We'll make sure they're widely said.
That's just a plot against you, Peter. It's fine.
My Lord, the next housekeeping point, my Lord Justice Arnold asked about the Supreme Court documents, and we do have a copy of the order and a copy of the application insofar as it includes the grounds of appeal. So we've got the whole document for you, but it's pages 17 and 18 where the grounds are contained, just to confirm that
will be useful.
And so, my lords, the final point.
So where should we put these for those of us who are operating on paper?
Perhaps they should go at the back of the authorities bundle or the back of the supplementary bundle, whichever your lordships find more convenient.
Well, I think authorities bundle is probably a good place. Sorry, the first document is entitled Additional Documents Required.
Yes, so there's a pro forma document, and then the grounds of appeal are set out in that additional document, and they are summarised on pages 17 and 18, although obviously there are other points, arguments made around that. But those pages 17 and 18 are the pages we refer to in our skeleton.
Thank you.
And the final hangover from yesterday, my lord, is the submission I was making at the end about Astrazeneca not seeking to rely at trial on material showing what had and had not been tested around the priority date. So just so you have...
You mean tested but not put in the application?
Indeed, or not tested, as the case might have been.
And it wasn't AstraZeneca, it was BMS?
Yes, so I'm referring to AstraZeneca not relying at trial, and of course the work had or had not been done by BMS.
You're quite right. So you spoke correctly. I cut across you. I apologise.
That's right, Mr. Just so your lordship has the full picture, AstraZeneca did give disclosure of various BMS lab notebooks.
Right.
Those were not seen by any experts, but were put in under a CEA notice.
Right.
We then had a discussion at the PTR about what reliance AstraZeneca was seeking to make of them and how we were meant to deal with them at trial, given that none of the experts had seen them. So the judge ordered the parties to go away after the PTR and decide whether they wanted to put any of the CEA materials to any of the experts at trial, and if they wished to do that, to explain why, and then there was going to be would have to be an application at the beginning of the trial to decide whether or not that was permissible. But in the event, both parties said they didn't wish to put any of the documents to any of the experts, and indeed AstraZeneca's skeleton stated expressly that it did not make any positive case based on the documents in the CEA notice, except they reserved their position in relation to whether DAPA had been made at all, which was never in dispute given the characterising data in the patent, so they didn't need to pursue that. So, my Lord, the CEA documents were never opened at trial and didn't play any part in the trial.
Right, thank you.
And there's a related point. My learned friend showed you the paragraph on the front of the patent referring to additional technical material yesterday.
Yes.
That was not a point made to the judge. And the judge did not, as a result, have any of that material, whatever it's referring to, before him. And so that material, whatever it is, didn't play any part in the trial either.
Okay, thank you.
So if I can return, please, to where I was at 4:30 yesterday. I'd showed you the Tapagliflozin case in tab 32 from the Dutch Court of Appeal, which appeared to apply a disclosure test to the application as filed, but found on the facts of that case that there was no disclosure, that dry granulation was better. And the final point on that case is that one of the cases my learned friend relies on from the EPO as applying G2 of 21 involves the very same patent. And that decision is at tab 25, where the TBA in that case came to the opposite conclusion as to the Dutch Court of Appeal and dismissed the opposition. So obviously both cases turned on the specific facts, but to that extent there's not even harmony between the Netherlands and the EPO.
Well,
at least
yes,
in that case.
it's not infrequent for different courts and tribunals around Europe applying the same test to reach different conclusions on the facts because of differences in the evidence and the arguments. That's common.
Of course that's possible, Marlon, but it does appear...
The question is are they applying the same test?
Yes, and we would say that they're not applying the same test because one court was looking for whether or not dry granulation was better, and the other court was simply looking to see whether dry granulation had been disclosed. And that's so we say there is an apparent difference. While I'm on the EPO case law, my learned friend hinted yesterday that they had found some 60 EPO cases which mention G2 of 21 since it's been handed down, but he explained he couldn't put them all in the bundle. Now, we've obviously reviewed the cases ourselves, and from the ones we've looked at, there are very few cases which actually discuss G2 of 21 in detail or how to apply the ruling. And a number of the cases where it has been applied, the technical effect has been refused based on limb 1 as not being encompassed by the teaching and not limb 2. So in our submission, you can and should assume that all the cases of interest or of assistance to the court are in the bundles. And my learned friend's reliance on pure numbers really can't assist him. My lords, there are 3 other senior court decisions around Europe worth looking at. The first is the Spanish Supreme Court case, which is at tab 36, which my learned friend took you to yesterday, so we again don't spend much time on it. It's bundle 3, tab 36. And if we could turn please to page 1571 of the decision. And it's correct, as my learned friend suggested, they seem to have applied the ab initio implausibility test. But if your lordships look at the end of the first paragraph on page 1571, where they say in the last 3 lines, they rely on the fact that the apixaban potency could be verified with tests described in the application. And,
where are you?
sorry, page 1571 of the bundle.
Yes.
First full paragraph. the last 3 lines, they rely on the fact that the potency of the apixaban could be verified with tests described in the application and forming part of the common general knowledge outlined above. Does your Lordship have that?
Yeah.
So they seem to be encouraged by the fact that the skilled person reading the document could go out and do some tests subsequently. That, of course, was a position rejected by Lord Sumption and Warner Lambert, which we've seen my learned friend accepts as the right test for second medical use patents. And we submit it's difficult to understand why you should be allowed to do a test after the event to check the technical contribution to the inventive step, but not for sufficiency. And of course, our submission is that you shouldn't be allowed to do such a test in either circumstance. So that's the Spanish court. Then the Swiss Federal Patent Court is at the next tab. And again, my learned friend did take you to that. And if I can just pick up on page 1663. And the important point we say is the observation in the the top paragraph on page 1663, that if the test is merely asking whether there is reason to doubt, then that would not prevent speculative applications, because there may be no reason to doubt because you just don't know. And that, we say, is an important...
I'm sorry, I'm again struggling.
Sorry.
1663.
Yes, and in the top paragraph, after the reference to T116 of 18...
Speculative applications are not prevented,
Yes. And we say, so that's an important observation which chimes with our policy arguments. And then they seem to apply an obviousness test. That's in the 3rd paragraph, which again is a different way of approaching it.
Well, you say it's different, which is obvious, but what's your submission about whether that's correct or not?
Well, that difficult to see how that comes out of G2 of 21. It may be if you're building into the obviousness argument an element of plausibility, then it comes to the same thing as the point we say G2 of 21 should be interpreted, but they appear to be using a different term at least. It's difficult to know whether that's arisen through translation issues or otherwise. Finally,
that can't be a translation issue, surely. I mean, that's such a well-known word in the context of patent law.
Yes, if it is an obviousness test, then plainly the expectation of success, whether you think it is going to be correct, is all part of that analysis. So we say that plausibility is included in that, and that would explain why they were keen not to alight on a test which allowed speculative applications, a pure disclosure or reason to doubt test, and they apply a higher standard.
All right.
Which may...
I'm sorry, I'm struggling to understand this. I'm sure it's my fault, but thinking back to what you said a moment ago about translation, I don't think it's a translation issue, but it may be a semantic issue nevertheless. Because even patent lawyers sometimes fall into the trap using well-known words to describe different concepts. So, do I understand a possible rationale is that when they say obvious, they don't mean obvious in the technical sense. What they mean is apparent.
That might be how they've dealt with it, my lord.
I appreciate you can't speak for the Federal Patent Court, but nevertheless, the purpose of this exercise is so that the parties can make submissions to us as to what understanding of other courts and what the approaches of other courts are.
Yes. So we know from the first paragraph that they have rejected the no reason to doubt test.
Yeah.
It needs to be more than that. And if that is the case, then our submission is that they must be incorporating some element of reason to believe, credibility, plausibility into the question as to whether the technical effect is obvious. It can't simply be I'm reading the document and I see a disclosure which tells me X. It's got to be more than that, given the policy considerations they've already considered further up. So, my Lord.
Yeah.
and like, Ms. Pickard helpfully indicates that the footnote at 62 does refer to G2 of 21, and they have emphasised the derived wording, emboldened that in the footnote, and that would imply there is some sort of exercise going on which is more than simply a disclosure. It's having to understand as well and believe. As you say, my lord, I'm afraid I'm unable to assist you any further as to what they were really thinking. The final case, my lord, which my learned friend didn't take you to yesterday, is the Norwegian Court of Appeal at tab 39. And we say it's significant he didn't feel able to comment on this because it's against him. Could your lordships pick it up, please, at page 1734? And after dealing with the case law, including Dapagliflozin and Ibsen, they describe at the very bottom, perhaps your lordship would read the bottom paragraph on 1734, please. And then they go on to discuss it in the middle of the following page. So right in the middle of the page, there's a sentence beginning, thus here is also seen. Does your lordship see that? Mm-hmm. Could I ask your lordships to read to the end of the next paragraph? So the Norwegian Court of Appeal, even with T116 of 18, decided that the standard had not been lowered by G2 of 21 and sought to apply an ab initio plausibility test, which of course is consistent with our submissions to this court. Your lordships have been supplied with a number of academic articles in addition to the case law. With the greatest respect, we say they don't advance matters very much. Yes, there is a range of views expressed, but that's to be expected. For example, Sir Robin Jacob didn't seem to think that speculative patents were a big enough problem to worry about at all, although that's not backed up by any evidence. He, in his article, thinks all the patent needs to do is disclose the technical effect, but that would allow speculative patents to be filed in our submission and would not cure the mischief that the boards of appeal have identified. Moreover, he says the solution is for a member of the public to do the test to verify whether or not the effect is real themselves, but that, of course, is contrary to Warner-Lambert. And we ask, why should the burden be on the member of the public? If the patentee has done the test, they should put the result in, and if they haven't done the test, they shouldn't file the patent until they have, and that's the principle of the first-to-file system. So we say that, with the greatest respect to Sir Robin, his views are not persuasive. Of the other articles, we commend the approach of Alison Slade in her article at tab 45, which requires not only disclosure but support, which is in line with the Warner-Lambert approach. And we also note in tab 48 the recent IPCAT report, where an EPO examiner confirmed that G2 of 21 had not changed the examination practice in the EPO. Of course, that's only one examiner, but it is further indication that G2 of 21 has not,
yes,
in fact.
I mean, in such a forum, a representative of the EPO will be bound to be speaking in their personal capacity and to make that clear.
Indeed. So, my lords, overall, we submit that there is just no basis to conclude that the approach the judge adopted was not in accordance with G2 of 21. At the very least, we are a long, long way from being in a position where it is established that the EPO is going in a different direction to the UK, and therefore the apixaban case should no longer be binding on your lordships. Whilst the words of the test may have been settled by the EBA decision, the way to apply those words is far from being settled. And indeed, we're not really any further advanced than we were when the Supreme Court looked at the apixaban application of Commission to Appeal itself. Indeed, the Supreme Court, when it looked at the application, had both the French and the Dutch Court of Appeal preliminary injunction decision before it, which of course are relied on by my learned friends. But if anything, the more recent EPO case law that I've shown you and the Swiss and the Norwegian courts have made it even less easy to say that there is a point of law at large. Because
I ask you this question. And the reason why this matters for our purposes, as Mr. Hinchcliffe was extremely clear about in his submissions to us yesterday, is with respect to claim 2, because that's the claim to the product per se, single chemical compound. He accepts that short of the Supreme Court, he is in difficulties with regard to claim 15 if he fails on grounds 1 to 3. And for this purpose, we have to make that assumption. Obviously, if he succeeds in all those grounds, all of this becomes academic anyway. And so, therefore, the question that really matters when we're considering the case law from the Boards of Appeal and the other EPC contracting state courts is what we get out of them, not with regard to medical use claims, and in particular sufficiency thereof, but what we get out of them with regard to single chemical compound claims. And I think gravamen of his argument was really directed to the latter proposition. I didn't understood him to be strongly arguing, and I may be wrong about this, but that you could be clear that the UK was going in the wrong direction so far as sufficiency was concerned at all, certainly not in relation to secondary medical use claims. I mean, he obviously didn't concede that, because in the Supreme Court he will argue differently if he gets it. But the core point he was making was, when you look at a single chemical compound claim, particularly from the perspective of obviousness, then you can say that the UK is going in the wrong direction. Now, I appreciate you've given the generality of your submissions on this issue, but could you just focus for a moment specifically on that way of looking at it?
yes, my lord, and I of course accept your lordship's characterisation of my own friend's position, and I've been trying to address it from the view of inventive step. So our position is that in apixaban you decided that it should be the same standard for inventive step and sufficiency. And we say there's no reason.
But it was common ground in that case. I mean, that's one of the oddities about that case, which commentators picked up on at the time, was both at first instance and in the Court of Appeal. It was common ground between those parties that it didn't make any difference whether you viewed matters from the perspective of inventive step or sufficiency. Mr. Hinchcliffe's argument is it does make a difference.
Yes, and our position is that it shouldn't make any difference. Yeah. So it should be the same standard, and it would be bizarre if it was a different standard. And if, as your lordship put to my own friend yesterday, if the hurdle for getting a broad product claim which can be asserted against any use of the product was lower than the hurdle for getting a specific second medical use claim, or in fact any use claim where the use is built into the claim itself. And this appears to the discrepancy appears to arise in the EPO because of the way in which they deal with these claims differently. They deal with one claim under sufficiency head and the other under inventive step head, and the way that they use the problem solution approach as a strict structure to assess inventive step. Now, the courts of this country are not confined to using problem solution, and this more flexible approach allows the same approach to have been adopted in relation to either a claim with a specific function written into it, or a claim where you're implying the function, such as the Idenix case. And my lord, in the end, you're doing the same thing. You're testing what is the technical contribution, and has it been achieved to a sufficient degree at the time you file your patent. And in our respectful submission, it makes no difference whether you're testing it for the purposes of a claim that has it written in or a claim that you've implied it in, because in the end, you're trying to achieve the same thing, which is to make sure that the patentee has in fact made the technical contribution which the monopoly is being given for at the time he or she filed the patent.
Yes, but with respect, Mr. Mitchison, that's an argument to say that I was right in what I said in BMS and Sandoz.
Yes.
But that's not the question at this stage, because Mr. Hinchcliffe made it clear that in this court, he was not challenging that reasoning from first principles. His argument is a different one, which he says, even if that's a perfectly reasonable point of view from first principles, he says we should nevertheless decide differently because everybody else in Europe is going in a different direction.
Yes.
And so that's the point of the reliance placed on the Wyeth case, where the judges at the Patent Court took the view that the better view was that you couldn't have a claim to a second medical use, but they acknowledged that the enlarged Court of Appeal had held the contrary, and they held that harmonisation trumped a pure view as a matter of principle.
Yes, so even if it's wrong, we should do it.
Yes.
Yes. So the point about that is it has to be settled,
Yep.
first of all. And it plainly hasn't been settled because the enlarged Board of Appeal didn't hear argument, and they expressly explained that, about sufficiency. And so in order for us to determine whether or not the test is the same or different, the EPO needs to explain what the standard is for inventive step, and if it is different.
All right, but I just want to press you a little further on this, because the logic of Mr. Hinchcliffe's argument is to say, short of the Supreme Court, so yeah, obviously if you get to the Supreme Court, all bets are off. But at this stage, his argument is, from the point of view of sufficiency, you can assume that the EPO and the United Kingdom are in lockstep. In that, and certainly for second medical use claims, and he doesn't distinguish first medical use claims. So medical use claims and sufficiency, you can assume we're in lockstep, no problem. It's ab initio plausibility for that purpose. But then the question is, well, what about inventive step? And specifically, what about inventive step with regard to single chemical compound claims? And so then he says, inventive step was front and centre in G221. Moreover, it's front and inventive step of single chemical compound claims is front and centre in at least the foreign decisions of national courts with respect to Pixaban, because that was the factual context in those cases. And so the argument is, if you view it from those perspectives, we're out of step.
Well, the argument can only be we're out of step because the EBA has used different words to express the test. It's not clear that the meaning of the test is any different, particularly when they have expressly said that all the preceding decisions which use the ab initio plausibility wording should stand. And so that's the quandary we find ourselves in. It's just not clear whether there is really meant to be a different test for inventive step, or whether it's the same policy notions wrapped up in a different form of wording, because for better or for worse, the enlarged board decided that it wished to move away from using the word plausible in its characterisation of the test. And we've seen, for instance, that the Norwegian Court of Appeal seemed to think that it was the same test. They applied the ab initio plausibility in the light of G2 of 21 and T116 of 18 to the apixaban case. So it's very difficult to say that it's plainly wrong for this court to be doing the same thing. And we would say that if it were to be argued out fully, then the policy reasons that we rely on would come to the fore, and the enlarged board would acknowledge that in fact they weren't intending to change the nature of the policy test, even if they changed the wording, and therefore it's business as usual, as some courts and some members of the EPO seem to think. So Lord, I'm not sure I can assist you any further, but that's where we end up. So that brings me on to ground 6, which is the ab initio implausibility appeal. And your lordships won't have, I haven't taken you to it yet, but there was lots of evidence from the medicinal chemists at trial about structural similarities and dissimilarities. And the judge's conclusions about that are contained in paragraphs 243 onwards of the judgment. And we say that they're not open to challenge because they're based on the evidence. And, but AstraZeneca recognise that they do have to challenge the finding in paragraph 251, the factual finding in 251, that there was reason for the skilled team to doubt that DAPA was an SGLT2 inhibitor, because we say it's fatal to their case, even if they're right about the law of plausibility. Now, their grounds of appeal recognise that they can't go behind the technical evidence and the findings of the judge. And they are forced to try to sidestep that by suggesting that the skilled person wouldn't have considered the material that led to the conclusion the judge reached. The problem for them is that the experts agreed that they would consider the material the judge considered. And so if I can take you to the judgment first of all and show you how the judge dealt with it. The starting point is paragraph 247 of the judgment on bundle page 91, which is where the judge referred to Fibrogen. And to that extent, Fibrogen held that there was no principle of law about prior references. It was all a question of context and fact, and that's what the judge applied, and we say he was correct to do so.
Well, that's not in dispute. On the contrary, Mr. Hinchliffe positively relies on that.
Indeed. So then we go to 248, where the judge records that it was Professor Potter, that's my learned friend's expert, his view that you would look up W0128 when reading the patent. And we say the judge accepted that rightly, and you can't go behind that, and I'll show you why in a moment. In 249, the judge also referred to the interest of the biologist in the 6-month rat study, and he accepted that because the searches hadn't been recreated, nobody could rely on those per se, but at the very least the interest of the biologist in this work was consistent with that of the medicinal chemist. And in 249 the judge goes on and says that the biologist reader of W0128 would see the papers expressly referred to and be interested to see if they contained the 6-month rat work. So in other words, even though the search wasn't recreated, that didn't matter because W0128 goes on to refer to 4 papers by the Tanabe group, and the biologist would go ahead and look at those to see if they had more information about the 6-month rat work which they would be interested in. And the judge also records in 249 that the medicinal chemist would want to look at those papers for SAR reasons to see if they could establish more about why the particular structures had been chosen. So, based on 249, there are 2 routes for those 4 papers to be in front of the skilled team. And there's a clear finding at the end of 249 by the judge that this would be the case whether the reader started with W0128 or started with the patent. Because if they read the patent, they see the reference to W0128 and they're sufficiently interested to go and read that, and they see the papers through that. And we say there's simply no basis for my learned friend to go behind this. It's a finding of the judge based on the evidence, and we say, indeed, there is ample support for that in the evidence. And I will, I'm afraid, tire you by just showing you those references, if I may. So in the supplemental bundle at tab 6, firstly, this is the first report of Professor Potter, that's my learned friend's medicinal chemistry expert, and in a paragraph 130, this is when he's dealing with the disclosure of the prior art, and he says, refers to the long-term studies, it's paragraph 130, I would expect the medicinal chemist to be interested in this work and to search for the original work, which they know comes from Tanabe. So that's the first point. And he says why, to understand the structures. And then in 132, over the page, he goes on to deal with the list of patents and papers in the prior art. And at this stage, in his first report, he says, second sentence, I would not necessarily expect the medicinal chemist to read these materials in full, but they may wish to look at some or all of them to gain a better understanding, etc. So at that stage, he was a little bit tentative, but he certainly thought that the skilled person would be interested in reading them, at least part of them. Then, if you turn on, please, to 197, this is where Professor Potter was dealing with the disclosure of the patent. And in 197, he notes that the patent refers back to W0128, that's little a, and then in 198, he explains, I would expect the medicinal chemist to look up both of these documents, and if they did so, they would see that, and then at the top of the next page, he would see that all of the compounds within that generic structure are said to be SGLT2 inhibitors. So he has clearly there said that if you read the patent, you would go and look up W0128. If we turn then on to his second report, can I show you, please, paragraph 29, his second. Tab 7.
7?
Tab 7, yes. And we're in a section headed the prior art, that's on 163. And then at paragraph 29, he goes into this subject in a bit more detail. And he says, as I said in paragraph 132 of my first report, I believe that the medicinal chemist would wish to look up some or all of the materials cited in W0128 to gain a better understanding of the area, etc. And he says, top of the next page, in relation to the 4 papers referred to, I believe the medicinal chemist would learn the following. So he goes into more detail here and sets out what he says the skilled person would gain, but he clearly accepts that they would read these 4 papers. And then if we go on to paragraph 50 of his report, this is his second report, he's now referring to the patent, and in the second sentence of paragraph 50 he repeats his assertion, while it's correct that no explicit explanation is provided, the patent does refer in paragraph 11 to W0128, which, as I stated in my first report, I would expect the medicinal chemist to read. In doing so, they would observe the prior art discussed in W0128 and the work focusing on O-aryl glucosides. And that is the Tanabe work that's referred to. And then finally, two extracts from the cross-examination, if I may, please. Firstly, three extracts. In tab 15, this is the cross-examination of Professor Potter, page 251, first of all. And on page 317 of the transcript, I first of all refer him to paragraph 132 of his first report, at line 11, which we've just looked at. And then I go on the next page, 318, I say to him that suggests that the skilled reader might be more interested in papers than in patents, because the papers have been peer-reviewed. But he pushes back on that, and he says, no, they'd also be interested in patents. That's the answer at line 10. And then I say, what about skilled, this is line 15, what about the skilled medicinal chemist in academia? And he says the skilled medicinal chemist in academia would be more keen on reading papers, but would still read patents, because they know there's a lot which does not permeate the consciousness of medicinal chemists in academia. And I ask about peer review, he says that gives some comfort. And then at the bottom of the page, the 4 papers that are referred to all from the Tanabe group, are they not? Yes. Your evidence in 130 is that the medicinal chemist would be interested in this work and would search for the original work, which they know comes from Tanabe. Do you see that? Yes, I believe he or she would do that. So he's a bit firmer in his oral evidence than he was in his first report. And then I ask at line 23, in your second report, you confirm that the medicinal chemist would look at the papers cited and go on to summarise some of what the medicinal chemist would learn from these papers. Yes, I believe so, yes. So he's absolutely clear there that the skilled medicinal chemist would read these papers when they saw the reference in W0128. Then on page 265 of the bundle, transcript page 373, I'm then talking about the patent, and I refer him to the equivalent passage in the patent about the 6-month study. And so I ask him at line 8, you are referring there to the Tanabe work? Yes, this is line 8 of 373. So page 265 of the bundle, my lord. 373 of the transcript, line 8. I ask him about the Tanabe work. Yes. And I say, you said the skilled person would search for such work when seeing identical wording in W0128. So I presume they would do the same when reading the same wording in the patent. Pause for reading. Yes. If that is mentioned, they would search for it. And I say, they would identify the same 4 papers that you commented on in your reply report, and which we've been over this morning. Yes. So he's absolutely unequivocal there that the skilled person reading the patent would also identify those 4 papers. And then the final passage is at page 268 of the bundle. And it's transcript 387. And the professor, I ask a question at line 12 about the relationship between the patent and the prior art. The patent is 211, that's the patent in suit, and 128 is W0128, the prior art. And the professor says, line 15, the medicinal chemist would read patent 211 and note that patent 128 is referenced in it. Yes. So they would find that patent if they looked, and then he could interpret whatever they wish from that patent in conjunction with the 211 patent. So again, he's confirming that the reader of the patent would read W0128, and then he'd earlier confirmed that they would also look up the papers. So, my lords, we say there's just no basis for my learned friend to undermine the evidence that the judge heard about this.
Well, I understood Mr. Hinchcliffe to make a different point. I mean, there is the point that you just addressed, but when you look at 251, actually it's not expressed in terms of a finding based on the evidence of the experts. It appears to be a finding based on the judge's interpretation of the papers.
Yes, yes. So this is the new point that my learned friend made yesterday, that the judge wasn't entitled to come to the decision he did in 251. And I'm afraid I do have to take a pleading point in relation to this. It's not in his grounds of appeal. If your lordship goes to the grounds at tab 2 of the core, paragraph 17. So the only point taken in the grounds of appeal was that the judge erred in taking account of the papers which were not referenced in the specification. So it's all about whether you can cross-refer. Now, with hindsight, it's perhaps possible to see this point in his skeleton, and I just show you that, my lord. It's paragraphs 161. Sorry, it's page 161 of the bundle. Sorry, 161 where it's introduced, paragraph 107, and then 162 at little e is where this point is hidden. And they say about papers, Professor Potter, he was cross-examined on the Tanabe papers at T3, 317 to 359. And then they say, however, the upshot of his evidence was that the Tanabe work on a compound called T1095 cannot inform you positively or negatively about the activity of DAPA. And they give a short reference. So, as he correctly states there, the cross-examination on the Tanabe documents spans some 42 pages of transcript, of which my learned friend relies on one tiny soundbite in the last page. Now, I'm not going to invite you to read, or even worse, to read out, all 42 pages to show you that there was ample basis for the judge's finding, but I do need to explain the point in a bit more detail, if I may. So can I show you in the judgment, first of all, if your lordships would look at page 90 of the judgment. And if your lordships go up to the figure at the top, the Florozin figure, and I want to point out three aspects of this figure. Firstly, can your lordship see that the ring on the left-hand side, which has got the two OH groups, that is called the B ring in the Tanabe work, and that will help you understand the short parts of the cross-examination I want to show you. And at the top of that ring, you can see an OH group, and that is at the 6 position. To the right of that ring, you can see a 3-carbon linker with a ketone group on, the double bond O. And then below that ring, you can see a link to the sugar, which is at the bottom, and that link has got an O in it, which is called the O-glucoside bond. So the structure is referred to, it's that there's the sugar molecule at the bottom, there's the B ring with the hydroxyls, 2 hydroxyls on it, one of being the OH at the top, and then there's the ketone linker to the A ring, which is the ring on the right-hand side. Now, if your lordships just turn back, please, to page 76 of the bundle, you can see the DAPA molecule portrayed, and what you need to see for the purposes of my submissions is that the 3 differences, at least, between DAPA and Florozin are that, first of all, going from left to right, there's no O-glucoside bond. The O has gone and it's now a C-glucoside link. Secondly, there's no OH on the B ring, which is the middle ring. Instead, there's a chlorine. And thirdly, the link between the B ring and the A ring on the far right-hand side is now a single carbon link with no ketone. So there are three differences: the two linkers and the OH group, which has gone amongst other differences. And the point of the Tanabe work was to show that altering any of the OH group or the link to the sugar or the link to the A ring on the far right in fluorescein would be thought to destroy activity. And that's what the judge summarised by use of the abstract, which he quotes at page 200 paragraph 250, page 92. And so if we can just turn to that, please. You can see line 3 of the quote. There was a strict structural requirement for activity. This is quoting from the abstract of one of the Tanabe papers. And then after they talk about a substituent or a flat ring, but then they say in the abstract, 5 lines down, but any change at the bridge part between the A and B rings or in the sugar moiety, so those are the two bridges, resulted in a complete lack of activity. And then they say the 6' OH group on the B ring was also necessary, and even small structural modifications of the 6 OH group reduced the activity considerably. So that's a summary of the Tanabe work, and one can see why, if that is the understanding that the skilled person takes of the Tanabe work, why they would think that DAPA would not have activity, because you have changed all three of those critical elements, the two linkers and the OH group. And that's the basis of the case which I put to Professor Potter. And although in that little soundbite at the end, he didn't, he cavilled and said he was still agnostic, we say that the overall thrust of the pages of evidence that I put to him were such that the judge was entitled to decide that, in fact, the skilled person seeing DAPA would think that it wouldn't work because of these three changes.
Well, can I just explore that a little further? Because for this purpose, there's no challenge to the proposition that there's nothing in these papers to support the suggestion that DAPAG would be an SGLT inhibitor. Then the question is, do the papers give the skilled team reason to doubt
Yes.
that it would be?
Yes.
And that's the focus of
Yes.
this attack.
Yes. And Professor Potter agreed on a number of occasions that changing any of these three elements was critical.
Right, well, perhaps you can show us your best one.
Yes, I will. So if we go, please, in the cross-examination bundle, sorry, it's supplemental bundle, tab 17, tab 15. And this whole section of cross-examination is the section that my learned friend refers to in his skeleton. So it's all relevant, and I'm going to show you the best bits. So first of all, page 253 of the bundle, and first point I put to, I go through all four of the papers, and when I take the paper which the abstract, which the judge quotes, I first of all put that abstract to the professor, and this is at line 15 on page 328 of the transcript. And so I ask him to read the abstract, and I say what the abstract is teaching is there is a strict structural requirement for activity. That seems correct, yes. So the medicinal chemist reading this is learning that if you want to maintain SGLT inhibitory activity, you're very restricted in what you can do with the fluorescein structure. And he says this is just one aspect of modifying the fluorescein structure. I'm not sure he or she would be so generous. So what the professor is saying is I accept that these changes are shown to be critical, but you may not be able to generalise for all changes from Florizin, which of course is a fair point. You can only take your conclusions from the data that you're shown. So I go on and I go into the detail of the paper. And firstly, top of page 331 of the transcript on the next page, I talk about the OH group. And at line 3, I say, these results suggest that the 6OH group is essential for the activity. I'm reading from the paper. And he says, yes, I can read that. And I say, the medicinal chemist is being told that the 6' group must be a hydroxy, otherwise the inhibitory activity is lost. And he says, which tallies with the idea that it hydrogen bonds with the ketone, but they've not mentioned that. So he's agreeing, but he's adding the additional thinking about the hydrogen bonding, which was also part of the discussion. Then on 332, line 2, I put to him the quote, accordingly the ketone on the bridge part is necessary to exhibit the activity. Yes. And he goes on to qualify. So I put the point again at line 14. But the teaching the ketone is necessary is right, is it not? In this sense, crudely speaking, the result is fine. Actually, extrapolating to the reasons is a different matter. And then I go on 333 to quote about the bridge structure at line 11, and I read him, these results suggest that the bridge structure is extremely important, and any modification of this part may reduce the activity. And he says yes, once again qualified by not knowing exactly what you've done for the confirmation. And then at 334, I bring up the O-glucoside at line 3, and at line 11 I say, yes, all I'm suggesting is that the reader would think that the O-glucoside was necessary for activity in this. He goes, yes, yes. And 16, the message that this paper clearly tells the reader is that in Florizin you must have the 6' hydroxy group for activity. Yes, yes. And you cannot play around with the linker structure and maintain activity. I think that is fair, line 22. And then 335, I refer him to line 6. There's a fairly strict conformational requirement for activity. Yes, he agreed with that. And then at 336, line 4, I say, yes, it is also true that if the medicinal chemist looks up these papers, they will receive a very clear message, tinker with the structure of Florizin at risk. That is their stock in trade. I do not think they will be disturbed by that. And then...
What do we take from that last answer?
That they know that, but that doesn't stop them going on and doing more experiments. So it's okay. He's not disagreeing with the
So you say that that's their stock in trade is an acceptance of the proposition you put to him.
Yes, and he actually accepts it a bit later on, more clearly, so I'll show you that as well. So if I could take you to 342, please, and this is the last passages. At line 17, I put to him his second report where we've looked at, I showed you the passages where he deals with the papers. At 17, I say, you explain in your second report that the Tanabe group had mitigated the issues associated with Florizin metabolism and off-target effects. Yes. That is, we discussed that. The other thing that this work teaches the medicinal chemist is the importance of staying as close as possible to Florizin structure, in particular, not altering the 6OH' in the B ring, as I said, crudely speaking, yes, not altering the linker, crudely speaking, and retaining the O-glycosidic blonde, yes. So, my lords, we say there was ample material before the judge for him not to accept that the skilled person would be agnostic, as Professor Potter later tried to suggest. It was a convenient way for him to just summarise the issues was by reference to that abstract, because the abstract summarised the lengthy cross-examination which I've shown you part of. And therefore the judge was fully entitled, in paragraph 251, to conclude as a matter of fact that there was material in these papers that would give the skilled team reason to doubt whether DAPA would be an SGLT2 inhibitor. And we say there's no way to go behind that fact finding, the finding of fact of the judge he was entitled to make. it's right that he then doesn't go on to apply the legal test in paragraph 262, the legal test from T116 of 18, legitimate reason to doubt in inverted commas, but that doesn't undermine the findings of fact that he's made. And we say it's absolutely clear in the first sentence of 262 that he is referring back to the findings of fact, including the finding of fact he made at the end of 251. And we say AstraZeneca is stuck with that finding of fact for the reasons I've given. It's absolutely fatal to AstraZeneca's attempt to rely on a lower standard of plausibility. There were no other factual findings made by the court because it was not asked to by AstraZeneca, and therefore, for this reason, AstraZeneca can never win on plausibility, whatever the law might be. So, my lords, that's ground 6, and my final submissions are in relation to technical contribution, ground 7 and 8, and the importance of this ground of invalidity is that it is independent of the plausibility finding, and it runs whatever the standard of plausibility may be. So it is a complete answer to everything that AstraZeneca has been saying, even if you're against me on the last ground and the point that AstraZeneca can't win on a standard of ab initio implausibility for the reasons found by the judge. So, my lord, I need to take you to the 2 cases which my learned friend took you to yesterday, just briefly, if I may. Firstly, Dr. Reddy's, which is in Authorities 1, tab 6. And in my submission, it's important to understand the facts of Dr. Reddy's in order to understand fully what Lord Justice Jacob was doing when he came to apply the law. And so if I may start on page 235 of the bundle, and this is where the judge, Lord Justice Jacob, introduces the patent in that case, and the molecule you'll see shown at paragraph 5, that's olanzapine. And then the olanzapine patent, in paragraph 7, we see acknowledges British patent 1533235. That is the 235 prior art, which he then goes later to compare. And the judge then sets out what the patent in suit in that case said. And if you go on to page 236 of the report of the bundle, after introducing the 235 prior art, the patent sets out, this is just under the square bracket where it says formula set out at the top of the page. It says the lead compound from this group, flumezepine, and it goes on to describe a test on flumezepine, but it describes various unattractive side effects as a result of that. So the lead compound in the prior art was called flumezepine, and that was expressly acknowledged by the patent in suit. And then paragraph 8, Lord Justice Jacob says, the patent in suit says that the compound which it discloses possesses surprising and unexpected properties by comparison with flumezepine, that is the prior art, and other related compounds. And then in paragraph 9, he sets out details of the advantages claimed in the patent in suit, and he says they're clearly based on real evaluations both in animals and in early clinical tests. And what he then goes on to quote is material in the patent in that case, explaining that olanzapine was highly efficacious and had low side effects. There was, just below the bottom hole punch, you can see that patent has a direct comparison with the prior art flumezepine, and explains that the side effects are lower. And then right at the bottom of the page, the patent in suit also had a comparison with what's said to be a closely analogous compound to ethyl, and then a whole load of chemicals, and that is ethyl olanzapine, which is the judge returns to later in the judgment. And then he goes on, paragraph 10, to set out further experimental work in that patent, and he summarises it in paragraph 11 by saying, so far as my experience goes, this information is much greater than that generally provided in a patent for a new pharmaceutical compound. And he's right, your Lordship will no doubt have your own experience of what sort of material patents normally include, but there's a significant amount in that patent before him in that case. So then he goes on to describe what's in the prior art, 235, and my learned friend took you to that paragraph 17 to 22, and it's right that he characterised that as being woolly, and one can see in that case the contrast between the detail of experiment, etc., contrast between the prior art and the patent. Then Lord Justice Jacob goes on to deal with the law, and my learned friend took you to that. There's no need to spend time on the prior approach of selection patents, as my learned friend rightly said. And he, in paragraph 40, Lord Justice Jacob says, well, let's go on to see what the EPO do, quite rightly. But in 41, he says, before examining how they do that, he makes some observations. And it's right that in 43, he goes on to discuss the nature of the prior art in a question of obviousness and whether it conveys serious technical teaching. But it has to be noted that he's doing this outside the context of the EPO case law. He's just making general observations about obviousness and about pieces of prior art. And of course, in that case, the judge below had to deal with matters on the basis of conventional obviousness, including the selection approach that Lord Justice Jacob put in the bin. And so it may not be surprising that elements of the decision here are a mix of conventional obviousness and EPO obviousness. And this is an example of where Lord Justice Jacob is doing that. So in 44, he turns away from that, and he goes on to say, what then does the EPO do? And he summarises it. It regards what can fairly be regarded as a mere arbitrary selection from a class as obvious. And he goes out to set out the law in the EPO, including agrevo in paragraph 45, and it's particularly 2.5.3 of agrevo, where there was the well-known passage about a mere arbitrary choice from a host of possible solutions cannot involve an inventive step. But they also go on to say, the last 4 lines of that quote, in order to be patentable, must not be arbitrary, but must be justified by a hitherto unknown technical effect, which is caused by those structural features which distinguish the claimed compounds from numerous other compounds. So the EPO in agrevo emphasising there needs to be a hitherto unknown technical effect, and of course there is no hitherto unknown technical effect asserted by Astrazeneca in this case. They abandoned that case before the trial. They abandoned any attempt to suggest that their molecule was better than example 12 or example 10, and so your lordships are not troubled with, and nor was the judge troubled with, having to deal with any hitherto unknown technical effect in this case. Lord Justice Jacob then goes on to deal with Wyeth, dopamine agonists, which is one of the cases quoted by the judge. And then at the end of this passage, my learned friend showed you paragraph 50, but paragraph 51 is also important, where he summarised the contention of Mr. Carr. Mr. Carr contended that a subclass or individual member of a prior art published class was taken to be obvious if it was a random selection from the earlier class. I have no difficulty with that. Such selection provides no technical contribution. Mankind can learn nothing new from it. We say that's precisely the case before your lordships precisely what the judge found and precisely why he was right to find that it lacked technical contribution.
Does random in that context simply mean not selected for a particular reason?
It means it does mean truly random. If the class is asserted to have an effect, then you're allowed to pick any molecule from that class. And if all you're doing is saying that molecule has that same effect, you cannot get a patent. So it does mean truly random.
Okay.
Well, it doesn't mean truly random, which is the point of my Lord's question.
I'm sorry.
Because it's a conscious choice by the subsequent patentee.
Yes, of course.
So in that sense, it's not random. What Lord Justice Jacob means is he's using random as a synonym for arbitrary.
Yes, I accept. I'm sorry if I didn't answer your lordship's question. My lord.
I'm sure that makes it as clear as everything to everybody else. And I'm equally sure that I can leave that on one side for a minute. Thank you.
Hopefully it will become clear as I continue, my lord. So, on the case before Lord Justice Jacob, there were asserted advantages over the prior art which were confirmed by the experiments in the patent. And so this was a case which there was a hitherto unknown technical effect, even though olanzapine fell within the broad marcouche disclosed in the prior art. And so that's why in 54 and 55, Lord Justice Jacob says that there was a real advantage and it wasn't an arbitrary selection. But of course, there's not even an advantage claimed in this present case, which is why where the outcome of Dr. Reddy's diverges from the outcome of the present case. And 56 and 57, where Lord Justice Jacob is seeking to rely on the vagueness of the prior art, we say is strictly obiter because he's already decided that there is not an arbitrary selection in 55. He's really referring here to the issues of obviousness more generally, and he's not suggesting that there needs to be some further analysis which goes on in relation to the prior art as the EPO apply it. And so, and that's confirmed by paragraph 58, where it's clear that the judge wasn't really dealing with obviousness at trial in the way that it was being put on appeal in the EPO approach. He was really dealing with it in the conventional sense, and that's why, no doubt, Lord Justice Jacob had observations to make which are more relevant to classical obviousness as it's known. Finally, in this, can I just take your lordships to Lord Justice Jacob's wingman in this case, the Master of the Rolls, who gave a judgment at paragraph 83 onwards, as Lord Neuberger, and at paragraph 101.
It matters not, but of course, being the Master of the
Yes,
Rolls, he was presiding.
Indeed, it would have been in this course as well. So, of course, my lord. So, what Lord Master of the Rolls did, he summarised the case law from 96 onwards, including T181 of 82, Siba Gaidi. And he goes on to summarise the principles in 99 and 100, which are, in our submission, identical to the summary that the effect is identical to the summary that Lord Justice Jacob gave. And then he makes additional observation in 101, and perhaps your lordships would just read 101 for yourselves, please. So what the EPO does, it has a sort of shortcut when you're seeking to apply this principle. And the shortcut is to say, let's look at the compound with the maximum structural resemblance, compare that to the compound in the patent, and see whether there's an advantage over that. And if there is an advantage over that, you can assume that there's an advantage over the molecules as a whole. So that's a way of, rather than having to try to deal with every molecule disclosed in the prior art, you take the one that looks most similar, and if there's an advantage over that, you say, well, that's good enough. And that's the way that the EPO deal with it. And then Lord Neuberger goes on to apply that to the case before him. In 112, he refers back to Sieber-Geigy, and he then at about 6 lines up from the bottom in 112, he says, the teaching of the patent as explained in paras 7 to 10 above discloses that a number of the compounds covered by 235 were tested and did not have the same beneficial therapeutic effect as olanzapine. Thus, there are thienobenzodiazepines, in particularly flumezepine, and particularly importantly, there is the closely related compound ethyl olanzapine. The latter compound differs from olanzapine in only one small respect. It has an ethyl group in one location, whereas olanzapine has a methyl group. And your lordships can, of course, see the similarity with the present case, at least from a chemistry perspective. And then he goes on to find in 114, perhaps your lordships could just read 114, where he summarises his findings by comparison to ethyl olanzapine. I think it's only necessary to read to the bottom of the page. So in that case, not only did the Court of Appeal set out the principles, but it then went on to apply those principles from the EPO to the case before it, and it was able to compare directly the closest molecule in the prior art, ethyl olanzapine, to olanzapine, and because the patent showed that there was an advantage over that, that satisfied the test, and therefore it was not arbitrary because there was a technical advantage substantiated by the patent. And of course that's the very point that Astrazeneca abandoned in this case prior to trial, and they didn't even attempt to prove that. So, my lords, with that introduction we can go to the judgment and see how the judge dealt with it.
Well, you said you were going to refer us to 2 authorities.
Oh, sorry, you're absolutely right. I'm very grateful, my lord. Apixaban was the other one. I should just show your lordships, which is Apixaban at first instance. So this was tab 15 of the second Congo authorities. And the only point I want to identify in Apixaban, this is picking it up on page 919, at the bottom of the page. The way that the Apixaban case was put shows that there were material differences between the technical contribution argument there and the one in the present case, and these arise in a number of ways. Firstly, very bottom of 919 in paragraph 237, the judge refers in the very last sentence, however, that teaching is referable to different classes of compounds than in 652, and while the classes cover Apixaban, they do not disclose it. So it's clear that in that case, because of the presence of the lactam group in Apixaban, the judge was classing the disclosure of the prior art as disclosing different classes of compounds, albeit that the class did encompass, or the Marcouche encompassed Apixaban.
So
the way he...
What's the difference? I don't understand it.
Well, in this case, there isn't a different class. DAPA is not a different class of compound to the molecule in example 12. It's just not. It's the same class. It's got all the structure is identical except for one small chemical change. Whereas in Apixaban, it appears to be the case that the judge perceived Apixaban as a different class of compounds to that in 652, because he repeats that in 239. 4 lines up from the bottom in 239, he says, albeit in relation to different classes of compounds. And then in 240, when he goes on to make this comparison between the prior art and the patent, he says, BMS's case depends on the patentee in 652 having named apixaban as a specific compound which has been made in quantity. That, of course, doesn't arise in this case, because it wasn't relied on, such that it could be inferred that the patentee thought it was promising, bolstered by its being a typical lactam, so that's another reference to the different class point, and the structural case. That information is not in the prior art, nor is the structural case in 652, it's in the CGK, as I've explained. So there are at least 3 differences in the cases, the apixaban case and the present case. There's the class lactam difference, there's the quantity difference, and there's the structural case difference. And so that's why you can't just read the facts of apixaban onto the facts of this case. So I'm grateful for that, my Lord, and now we're going to go to the judgment and see how the judge dealt with matters. And he set out the law, first of all, at some length, paragraphs 39 to 59, and that wasn't challenged by my learned friend, and we say, rightly so. It is the law is, in our respective position, identical in the UK as the EPO following Dr. Reddy's. You need to have an advantage or technical advance over the prior art. That's usually shown by reference to the closest structural molecule in the prior art. If that's not present, and the patent merely claims an alternative, then it doesn't matter that there's no pointer to the patented molecule in the prior art. It can be picked at random from a large number within the marcouche, because they are all equally obvious mere alternatives. So there is no technical contribution if the patent is not plausible, but there's also no technical contribution even if it is plausible where there is no advantage claimed, which is the case even on AstraZeneca's own approach. And that's why the judge's finding of lack of technical contribution is unassailable and therefore completely fatal to AstraZeneca's patent in this case. So if we go on to see how the judge dealt with applying the law to the facts, firstly, as a matter of background, the judge held in paragraph 202 that SGLT2 inhibitors was an established field. And the relevance of that is that he was then able to find in paragraph 187 that, or running up to 187, that the material in paragraphs 2 and to 10 of the patent were also in W0128, and so they were not part of the technical contribution made by the patentee, whether or not they were common general knowledge. But in fact, it turns out that most of it was common general knowledge for the reasons the judge found. The judge then went on to identify the contribution in 195, and he defined that as the provision of a new compound of a type previously proposed for the same purpose, that is, as an SGLT2 inhibitor. Now, in paragraphs 221 to 223, the judge recorded the shifting technical contribution case put forward by AstraZeneca, but he concludes that, rightly so, that AstraZeneca abandoned any reliance on comparison with the prior art, and that's why he didn't need to do that. And then he goes on in the final section of the judgment to determine the question of arbitrary selection at 263 onwards. Firstly, he deals with the difference between classical obviousness and lack of technical contribution, that's not challenged on appeal. My learned friend tries to make some prejudice out of it, but it's completely irrelevant, as the judge found. Then at 266 to 268, the judge recorded correctly what AstraZeneca's case was not. It was not AstraZeneca's case that the compound was any better than a specific compound in the prior art. And this is where we turn back to Lord Neuberger's description of the EPO approach and the conventional approach to show that something is better than the closest molecule in the prior art, which would have been example 12 in W0128. And so, whilst AstraZeneca's pleaded case was that DAPA was better than example 12, that was not a case they advanced at trial. And my lord, this is really the EPO approach to look for the closest molecule in the prior art is a way of examining each of these cases on the facts. And we say each case is indeed fact sensitive. And so my learned friend's assertion, his way of trying to get into this, is to suggest that if you have an implausible piece of prior art, then you shouldn't be able to make an allegation of lack of technical contribution. And of course, the prior art itself may not be a patent. It may be a scientific document or something. So the same issues of plausibility as we see in patent cases may not arise. But if you have a truly implausible piece of prior art, then the skilled person puts it in the bin. They discard it because they think it's nonsense. And that's the way which one might argue how to deal with an implausible piece of prior art, but that's not what AstraZeneca did in this case, because of course they were relying on the disclosure of W0128 to attempt to justify the plausibility of their own patent. The alternative way of dealing with an implausible piece of prior art is to test it out, and if you find that it doesn't work, then you're able to say in your patent that the product you are claiming in your new patent is better than the prior art because the prior art didn't work. And so that's how you do that. So you can think of absurd examples. You could have an example where the prior art said, we claim all molecules containing hydrogen, carbon, and oxygen, and those act as inhibitors for SGLT2, and say the prior art gave no examples. All you would need to do in that case was to say that you had an advantage for the specific example.
Well, that would be in your first class. That would be obvious nonsense.
Okay.
And so it would be disregarded on that basis.
Yes. So say you had an example of a sugar molecule as being given in the prior art. Then all you need to do is show that your molecule you've selected is better than the sugar molecule in the prior art. That's the closest one. Or if the closest molecule in the prior art was example 12, then you would need to show it's better than example 12. And that is not what AstraZeneca did in this case. So we say there's no problem by the EPO approach somehow allowing this argument of lack of technical contribution to succeed where you've got a bit of prior art which is not plausible. That just doesn't arise. And it certainly doesn't arise on the facts of this case where the disclosure of the prior art is almost equivalent to the disclosure of the patent, and so they're in lockstep. And that's why AstraZeneca have such problems with this part of the case before you. So, my lords, we say that when the judge reached the conclusion he did in 269, which is effectively his ratio on lack of technical contribution, his approach is unimpeachable. He has been applying the settled law. He has observed that there is no advantage claimed for DAPA, and therefore, because DAPA falls within the class of molecules disclosed for the same purpose in the prior art, there is a lack of technical contribution because it is arbitrary, because no advantage has been claimed. We say that is absolutely conventional and unimpeachable. Then the judge then has to turn to the Astrazeneca arguments. He's already recorded how they shifted in the course of the trial, but by the time of closing, the argument was that DAPA was more plausible from the patent, or was plausible from the patent but not the prior art. But we say that's not the right test for technical contribution, lack of technical contribution. As discussed already at some length, plausibility is a threshold test which is part of the analysis of inventive step or sufficiency. When you get to analyse the invention and the technical contribution for the purposes of lack of technical contribution, you need to be looking at what is the actual technical effect, not merely that whether something may be plausible. And that, of course, goes back to Lord Hoffman in Connor, making the point that Lord Sumption repeated in Warner Lambert, paragraph 37. It's hard to see how the notion that something is worth trying or might have some effect can be described as an invention. So we say...
understand that, because particularly when you go back to Connor, I mean, the whole point of that case was he was plausible, and that was enough. You didn't have to show that it actually worked.
No, but the invention cannot be... The invention is that, in Connor, was that it treated stenosis.
That was the claim.
The claim, and that is...
But when you looked at the patent, there was no proof of that. It was a claim that was undisputed to be plausible.
Yes, so it got over the hurdle of plausibility, and then Lord Hoffman said you then analyse obviousness by reference to the claim, the actual benefit that it does treat restenosis. And so you're not allowed to analyse technical effect by reference to what something might do. And that's the point the judge is making in paragraph 271. And he also makes the point that the technical effect which AstraZeneca sought to advance in closing, that is to say that the patent makes DAPA plausible, was not a technical effect that had been pleaded. That's a further reason why he rejected this argument, and he was right to do so. And the judge wasn't asked to make a finding of fact about whether DAPA was plausible in the patent for the purposes of lack of technical contribution. In any event, the case failed on the facts, and this is what he goes on to deal with in 272. And that's because the disclosures of W0128 and the patent are in lockstep with each other. And at the very least, if DAPA is plausible in the patent, then the examples must be plausible in the prior art, which includes example 12, which differs from DAPA by only one methyl group. And the judge quotes the evidence from AstraZeneca's expert in paragraph 273. And my learned friend has not suggested that the judge was not entitled to reach the conclusion he did in 276 about the effect of this evidence. And in 277, we say there's no basis to suggest that changing the methyl to the ethyl would destroy activity, as the judge found, and that there was ample evidence before him to justify that. And can I show you that very briefly, please? So in the supplemental bundle, if I go to tab 7, please, first of all. And tab 7, first of all, in paragraph 36, this is first of all, this is where the judge gets his quote at 273. So just so your lordships have the record, particularly the last sentence of paragraph 36, the reasonable assumption that at least the examples would have been tested for activity. And then, if your lordship just turns the page to 37, the last sentence of the page, whilst it's correct to say that such data are necessary to confirm this, and no data from animal models are presented in W0128, the medicinal chemist would see the compounds presented in W0128 as a well-developed series of compounds which the patentee had generated to develop its SAR within this structural class. So that's AstraZeneca's expert saying that the prior art disclosed a well-developed series of compounds. Then if you go please forward to 47, this is the point I made just a little earlier, the last sentence of 47. As I noted in paragraph 237 of my first report, the medicinal chemist would further have noted the structural similarity between DAPA and the compounds of W0128 and fluorazine, and would be reassured by this to make a reasonable prediction of activity. So AstraZeneca's...
For these purposes, we have to proceed on the basis that he's wrong about that.
Well, no, you don't, because if the patent's not plausible...
sorry, no, we assume he's right.
Assume he's right, indeed.
Yes, sorry,
Because AstraZeneca were having to rely on the prior art to try and boost their plausibility arguments. So we say it's just not open to AstraZeneca to try and rely on, discard their own evidence when their own expert was saying that W0128 was plausible. And then this arose in the cross-examination as well, and if we look at it in tab 15, at page 269 of the bundle, and right at the end of Professor Potter's cross-examination, so he gives an answer at line 6, where he said, sorry, 390 in the transcript, line 6. He's saying DAPAG has been selected from a number of compounds, so one has to assume it has special properties to make it worthwhile. Just pausing there, the expert was assuming DAPA had special properties, but of course that wasn't AstraZeneca's case. They'd abandoned that case. Their case was it was just another SGLT2 inhibitor. And then I ask him at line 14, I say to him, well, the medicinal chemist is simply assuming that DAPA was in some unspecified way better than the compounds of W0128, correct? And he says, not better than all the compounds in W0128. It stood out as being good. There may be other compounds in 128 which are as good, but have not been selected or filed upon. There's a huge number of compounds anyway, so it's impossible to say. There could be many other compounds in 128 which are very good. We don't know. There is no data. Then I go on, no, there's simply no technical reason for the medicinal chemist to assume that the compound in the patent is any better than any of the compounds in W0128, correct? Not in the absence of data, no. So we say there was ample material for the judge to find that there was no material difference between the disclosures of W0128 and the patent, and to make the findings that he did in paragraph 278 about the lack of technical contribution, even on AstraZeneca's wrong approach to the law. Those findings were based on evidence put forward by AstraZeneca's own experts, and so when he goes on in 279 to apply the law as explained in Agrivo and Dr. Reddy's, he's applying the law as has been applied in multiple examples in the bundles, and on which he's already quoted, where there is no technical advantage and the claim is to a mere alternative, there's no need for a pointer. In contrast to this case, Dr. Reddy's was a case where there were multiple established advantages over the prior art, higher efficacy and lower side effects, which were established by experiments reported in the patent. In contrast, this case, the effect of DAPA was no different from that predicted in the prior art. There were no advantageous properties claimed. It was therefore an arbitrary selection. And this is the inescapable trap that AstraZeneca find themselves in because of the very close relationship between the prior art and the patent in this case. And so for all those reasons, we say the judge was absolutely right to find lack of technical contribution based on the documents and the evidence before him. My Lords, unless I can help you any further, those are our submissions.
No, thank you very much, Mr. Mitchison, to you and to those that sit with you. Yes. Should we have a short break? All right. We'll return at 11:45.
Don't go reading the front because it's a discretionary text. But in the second place, it's most I must go down to counter. And we did say they need to, if they're going to take this case, they're going to do it. Well, I will. Here it is. You'll see paragraph 9.
Yes.
Katie, you've got my copy, Jack.
Yeah, it's got chilly matins on the way through. Yeah. Maybe you could ask to have your wigs and gowns back on. Well, it's so warm, it best be hotter, so it makes sense to kind of sit for that day in the anticipation that we'll do the same thing. What rise and table?
So here's what it is.
My lords, I'll be as concise as I can. So going back to grounds 1 to 3 to start with, on the issue of whether the patents discloses that the skilled person that dapagliflozin has been tested, first point to keep in mind is that my learned friend's argument proceeds on the basis that something had been tested. His case, of course, is that it was things that we tested in the course of validating the assay. But we say once you accept that the skilled person reading the patent understands that something has been tested, as my Lord Justice Stuart-Smith puts my learned friend, why would the skilled person understand that the reference to the inhibitor in paragraph 115 as having been tested be anything other than reference to the single inhibitor compound that the patent is all about? And what would be the point of the patent referring to testing done to set up the assay? And in our submission, we say it would never cross the skilled person's mind that the compound that had been tested was anything other than a compound of Formula 1. Now, on the evidence in relation to this point, my learned friend was very keen on a passage of cross-examination where, perhaps I can just remind you, it's probably easier to do from the actual transcript. So that's supplemental bundle tab 17. And it's bundle page 291, internal page 6112, I think probably heavily marked by now. And he particularly likes the question and answer at line 22. You just don't know what has been tested in the assay, Professor. You are correct, I do not know what was tested. And he submitted to you yesterday that meant Professor Bailey wasn't even suggesting that dapagliflozin had been tested. But my lords have to just lift one's eyes up to the earlier passage that had just been through, where Professor Bailey had made it very clear that his view, the skilled person had understood it had been tested. So we see that in 612 at line 15. There's only one molecule here, so presumably it's going to have been tested. And then even in the answer immediately before the one my learned friend likes, at 612, in line 11, the professor says, it says it was, so I assume it was. Professor, the patent never says the molecule was being tested. The assay was performed, it said, did it not? So I've just taken an assumption, if you like, if it said it's been done, it's been done. I have no reason to believe that it was not done. So that was the professor's clear view and consistent throughout his cross-examination. And then when we get to that last question and answer, we say all the professor was accepting was it wasn't clear what other compounds have been tested in the course of validating. He was very firm that he understood that dapagliflozin itself had. So therefore, there's also nothing in the point that there was no re-examination on that, because the professor has been very clear what he thought had been tested. And similarly, I put my bundle away, but I shouldn't have done, on my learned friend's typo point, which is a slightly convoluted one, but the argument proceeds on the basis that the skilled person looks at paragraph 1 in the patent and sees that it says inhibitors rather than inhibitor. And he then sees the reference to the prior art. He reads the prior art. He sees similar language in the prior art.
Identical in the passage.
And says to himself, I wonder whether this has just been copied and pasted over.
Well,
and therefore,
do you dispute that that's the obvious conclusion, given the identity of the language and the fact that it's the same applicant?
Well, it's not the inevitable conclusion, because of course, claim
can you
1...
postulate any other rational explanation for identical language to appear in successive applications by the same applicant? Well, I mean, come on, this is not monkeys typing Shakespeare.
No, my lord, but there might be a reason for it, which is that we've been focusing on claim 2 of the patent, which is to a single molecule, but claim 1 also covered stereoisomers of dapagliflozin. And so...
What's that got to do with it? We're concerned with the language about the assay.
No,
this identical.
No, this is not about the assay, my lord. This is the opening paragraph of the patent. I'm sorry, we may be at cross purposes. It sounds like we are. So if my lord just goes in the supplemental bundle to tab 1, it's paragraph 1 of the patent that this point was made in relation to. The present invention relates to C-aryl glucosides, which are inhibitors of sodium glucose dependent transporters. So that's the S. That's the S that my learned friend focuses on. And it is fair to say that that paragraph appears verbatim in the prior art. And the point that was put was that the skilled person would see that S, think it was, and then having looked at the pattern, think that that was a typo because it had been carried over, and therefore think in the patent, rather than talking about dapagliflozin, it in fact was talking about having tested things in the prior art. Now, that's obviously a very convoluted mental process for the skilled person to go through.
That's a submission I perfectly understand, but I thought, and maybe I was misunderstanding, that you were disputing the premise of the argument, which is that the skilled person would see that one document was copied to the extent of about 99% from the other.
Yes, but
Are you disputing that premise?
No, my lord, but it's not that it was. There are reasons why there might inhibitors plural might be mentioned in the first line of the patent, and that's because of claim one. I mean, it's not my main point, my lord. My primary.
I'm struggling to understand the point you're making. I get. I mean, as I understand, the only point about inhibitors is it's an immediate giveaway to the reader that there's something faintly peculiar about this document because it uses the plural when it's only talking about one. And as soon as you look through it, you understand why, which is it's a small error in the cut and paste job.
Well, my lord, I say that's not quite accurate because if my lord goes to claim one, claim one, compound of the structure, that is dapagliflozin, or pharmaceutically acceptable salts, or stereoisomers, or prodrug acid thereof. So there are multiple different chemical inhibitors within the scope of that claim, and that's the only point I'm seeking to make, my lord. And it's probably because we've all focused on claim 2 for the purposes of the appeal.
All right. So you say plural inhibitors is literally true.
Yes.
Right. Okay. Well, fine. Okay. Now I've understood that. Belatedly, and I apologise for being slow. But given, so what conclusion do you draw from that?
Well, that it isn't an inevitable conclusion that you look at it and go, it must be copied. But of course, we do accept the skilled person who does then read 128 would see the close similarities in documents. But the overwhelming, the overriding submission, my lord, is one that this chasing through the documents and looking and considering that they may be copied, it's an exercise that the skilled person simply wouldn't undertake. And we say they would simply look at the most simple explanation for when it says inhibitor, what does it mean? The skilled person would understand it to mean.
Well, I understand the overall submission, but I need to be a little clearer as to precisely how you put it. So let's break it down into stages. Question 1. Do you dispute that the skilled team would look at W128?
No.
Right. Question 2. Do you dispute that the skilled team, once they looked at W128, would instantly appreciate that this patent is 99% copied from 128?
They would see the overwhelming similarities, yes.
Right. So where you part company with Mr. Hitchison is what conclusions they would draw.
Yes.
Yeah. Okay.
And it's the convoluted reasoning, and as always in life, often the simplest explanation is always the correct one. That's all I wanted to say in relation to grounds 1 to 3. So then, moving on to plausibility and G2 of 2021, perhaps we can get that out because there's a few points we might need to have in front of us. So that's bundle authorities bundle 2, tab 20. And if we could start with paragraph 71. Which is on bundle page 1139. And this is where they say the relevant question according to the board is what the skilled person with the common general knowledge understands at the filing date from the application as originally filed as the technical teaching of the claimed inventions. And then they go on to say that they don't think the outcome applying that test that they then go on to develop in the rest of the judgment would have been any different in any of the previous cases. And my Lord Lord Justice Arnold put to my learned friend that the only way, my submission, that the only way that you can reconcile that with the two lines of cases was if they were, as my Lord put it, levelling down to an ab initio implausibility test. And the only answer my learned friend had to that was, well, that must mean that Johns Hopkins was decided wrongly. And can I show you, models, why that doesn't follow? So if we can go back to paragraph 66 on page 1130, see the quote from Johns Hopkins there. And as my lords will remember, but just to be clear, the patent in Johns Hopkins was claiming a molecule called GDF9, which it said was a member of something called the TGF-beta superfamily. Now, there was no data in the patent showing that it had similar properties to those other family members, and indeed the structure of GDF9 was significantly diverged from those other family members. We see that in the first 3 lines of the quote on page 1130. So when we go over the page and they say in the bolden text, according as a significant structural features fail to be identical in TGF9 and the members of the TGF-beta superfamily, and no functional characterization of TGF9 is forthcoming in the application, so there's no data, it's concluded that the application does not sufficiently identify this factor as a member of the family. There's not enough information to make it at least plausible that the solution was found to the problem which was purportedly solved. In effect, that decision is that it was implausible on the face of
So we rewrite not enough to make it plausible to mean it's implausible.
Well, that doesn't. Well, the two aren't inconsistent with each other, because the way they expressed it was there was nothing to make it plausible. But actually, if you analyse what there was an assertion that it was a member of a superfamily when it had significant structural differences from all other known members of that superfamily, and no data to show that it behaved in the same way. So one can see how the enlarged board would look at that and say, well, that could be rationalised as that would have been, there were reasons to doubt that it was in the same family.
So that's Johns Hopkins. The other one that my learned friend didn't address it from this aspect is how can one reconcile the cases in class 2 with the enlarged board maintaining an ab initio plausibility test. And perhaps if we go on to page 1136 of the bundle and page 48 of the judgment, T536 of 07, there was no working examples of the claim subject matter in the suggested patents, and it's not disclosed as a preferred embodiment, but there is no a priori reason for the skilled person to consider it not to be a plausible solution in the above mentioned technical problem. And so that was a patent, but there was no data, but because it was not implausible, they allowed them to rely upon post-published file data and to show that the effect was real. That can't be squared with applying an ab initio plausibility test. It just simply doesn't work as a matter of logic. So that's those points. Then if we can go on to paragraph 77 and the comparison with insufficiency. And my learner friend suggested that this paragraph is simply, if you like, a statement of objective fact, reflecting the fact that for second medical use claims, because the therapeutic use is written into the claim, the patentee has less flexibility to change his technical effects than for inventive step of a product claim. And we say that's not right. What the enlarged board are clearly doing is drawing out, having been through the 3 sets of cases, the 2 sets of cases on inventive step and then the set of cases on sufficiency, that there are different requirements and the threshold is higher for insufficiency. I mean, indeed, this is headed intermediate conclusion. It's not a here's a practical reality of life, but we make nothing of it. What they're doing here is, having reviewed all sets of all the sets of cases, they've come to a conclusion as to the effect of them. And of course, this paragraph has been interpreted in the way that we suggest by the Dutch Court of Appeal in the Apixaban injunction case. That's in with the authority at tab 30 in this bundle, at paragraph 6.9. And well, one has to ask the question, if, as my learned friend suggests, the enlarged board, the effect of this decision is applying the same test to inventive step as to insufficiency, why on earth did they not say you can rely upon an inventive post-file data if proof of the therapeutic effect is provided in the application as filed, and particularly in the absence of experimental data, it wouldn't be credible. They could have used exactly the same language and written that into the order, but they didn't do so. So that brings me on to a theme of my learned friend's submissions, which was based on the word derive in the order. And so perhaps if my lords go to the last page of this tab, just so we've got it in front of us. And what he was seeking to do was to hang on the word derive, that this effectively in bringing ab initio plausibility back in via that word. Now, we say that the word derive in paragraph 2 of the order relates to the first limb of the test. So the skilled person has to be able to derive the effect as being encompassed by the technical teaching. And what that's doing is it's making it clear that it isn't, the first limb isn't a simple disclosure test in the sense of how the EPO would understand in terms of added matter or novelty, that there has to be a clear and unambiguous disclosure of the effect. The test allows a bit more flexibility, and it allows the skilled person to look at what the patent teaches and come to a conclusion as to whether that's the effect that the patent's talking about. And that's how that's been interpreted, certainly by the technical board in 116 of 18. So if my lords just turn on to the next tab and go to paragraph 11.10 of that, which is on page 1179. They say, in light of this, for requirement 1 of order 2 to be met, the purported technical effect together with the claim subject matter need only be conceptually comprised by the board's technical teaching. This in turn means that the said effect need not be literally disclosed by way of a positive verbal statement. Instead, for example, it may also be sufficient that the skilled person, having the common general knowledge in mind and based on the application as filed, recognises that the said effect is necessarily relevant to the claim subject matter. So that's what we say the word derive is doing. It's allowing the skilled person to recognise, based on the teaching, the technical effect is relevant. It doesn't import in all of the ab initio plausibility law. Now, further point on this decision, my learned friend said that this board disagreed with the Dutch court in the Apixaban case, and he showed you a short passage on page 1186 and made a very superficial, high-level submission as to that. One needs to look at this all in context. So in 1185, so this is where the board's dealing with national case law. They've just dealt with our case law. And then in the bottom paragraph they say, in the same way as the present decision, the decision in the Apixaban case by the Court of Appeal of The Hague, published after the date, held that Order Number 2 of G221 does not require for a patent applicant or proprietor to be able to rely upon a purported technical effect. The application is filed always to have included evidence that the purported technical effect actually occurs. So the two of them are agreeing on that point. And then say, unlike the present decision, the decision of the Dutch Court of Appeal considers the criteria Order Number 2 to be met if the application is filed expressly and specifically designates the relevant effect as the primary objective of the patent. As set out above, and there's a reference back to 1110 that we've just seen, in the board's view, a positive verbal statement about the purported effect need not necessarily be present in the application as filed for the requirements to be met. So this is all about the other limb of G2 of 21 that we're not concerned about in this case, because our patent clearly and expressly discloses that dapagliflozin is an SGLT2 inhibitor. So insofar as they're not agreeing with them, it's on a point that doesn't matter for your lordships. What they do agree with them on is the key aspect that proof is not necessary in the actual specification. So, next, right at the end yesterday afternoon, and again first thing this morning, my learned friend made some submissions about what AstraZeneca did or didn't seek to rely upon, showing what it did or didn't do before the priority date. Now, my learned friend made a very careful submission on that. I just want to ensure your lordships don't read too much into it. He is correct that has been no part of our positive case to rely upon any work that was done either before or after the priority date. However, as he explained at trial, before trial, the respondents sought and we provided disclosure from BMS showing their research documents as to what they did before and after the priority date. And some of that was made the subject of a CEA notice that was before the court at trial, but didn't play a large part. Now, it is no part of my learned friend's case that this invention was made only after the priority date. And my lords can't read into his submission as to what wasn't part of our case, as to what may or may not have happened. I can't take any further than that before your lordships. But no party relied upon what did or didn't happen. So, well, then coming on to the cases following on from G2 of 21. He obviously has his single TBA case that he likes that queried some of the reasoning in T116 of 18. But as I think my laws have got, ultimately they didn't need to decide about what the relevant test was, and they did down the patentee essentially on the basis that the new technical effects it was seeking to rely upon was inconsistent with what the patent actually said, so it failed on the first limb. And that's, my laws want to look at it, that's in the paragraph 614 of that decision, just after the bit that my learned friend likes. He also makes a point on the date of publication of the decision of that judgment. And it is right that it was only published on the 20th of December last year. But that's not really an answer to the point that it's the only decision of the Technical Boards of Appeal since G2 of 21 in 2023, because the other boards are able to look at G2 of 21, form their own view as to what they think it teaches and requires, and apply it. They don't need to have seen the decision in my own friend's technical board case to be able to form their own view as to what the relevant law is. So it isn't a complete answer to the point that people haven't had time to read that decision. And it does remain the case that despite the time between G2 of 21 and now, there are no other Technical Board of Appeal decisions supporting his position. So when we get to the issue of settled, is the position settled? My laws, I think have our submissions. There is the enlarged board decision that settles the law. One doesn't say in this jurisdiction the law isn't settled because the Supreme Court have given a test, but that's perhaps difficult to apply in some circumstances. One doesn't say with the Court of Justice decisions they've construed this particular European instrument, but that doesn't settle the law because, again, there's issues of how it would be applied. These superior courts, their decisions on matters of law settle the law. And in any event, he only has a single isolated technical board of appeal decision that queries in an obiter sense the interpretation that we rely upon. And as the Supreme Court made clear in cases like Eli Lilly, we shouldn't be swayed by single technical board decisions. One has to look for the general trend of all of them. My learned friend also, and I'll come to some of the detail in a moment, picked at a few points in some of the national court decisions, but the fact remains that those decisions, there are no national court decisions that support my learned friend's view of the law. The best he has possibly is the Norwegian decision, but I'll come on to show your lordships why it's not quite so straightforward. My lord, this morning he started with the order of the Supreme Court in Pixabat. Well, it might be helpful, or maybe just for completeness, I don't want to address anything on it, but does my lords have the statement of opposition in that, so one can see what was said by the opponents resisting permission to appeal.
Thank you. And what do we get out of
Well,
this?
what you get out of it is that a point that was advanced by the respondents was that any decision on the level would have been academic because factual findings meant that it didn't matter. That's paragraph 19. It is true that they also argued that there was no arguable point of law as well. But as my lord knows, the Supreme Court won't usually take cases on to decide points of law when they don't matter for the purposes of the case in hand. But I mean, ultimately, my lord, the Supreme Court have a discretionary test as to whether they grant permission or not, and we don't know the precise reasons why they did. And as I submitted yesterday, refusal of permission to appeal has no precedential value. So there's not much one can take from that. Now, my learned friend made a point in relation to the case at Authorities Bundle 2, tab 25. Sorry, mine was doing the filing.
Yeah.
Which was, I think this is the one that he said the technical board came to a different conclusion to one of the national court cases that I rely upon. I can't remember which one it is, but it was when my Lord Justice Arnold said this morning, well, it may have came to a different result, but the real issue is whether they were applying the same test. And can I just show you that they were applying the same test? So this is tab 25, and if we go to page 1344 of the bundle, we can see this is where they start discussing G2 of 21, and then on the next page, 4.3.7, they say it remains to be determined whether the second criteria set in G2 of 21 was met, i.e. whether the invention is embodied by the same which is disclosed in the invention, and then they go on to discuss the facts, and then in the bottom, 5 lines up, in this specific case, on a very low number of embodiments defined in the original application, one of these also being the subject matter, the closest prior art, and the other one the preferred. In the absence of any legitimate reason to effectively to doubt that the alleged effect could be achieved with the claimed subject matter, CT 116 of 8, the board is of the opinion that the appellant proprietor should be entitled to specify a preference for one of the others. And then 4.3.8, they go on to allow them to rely on the post-published data. So very clearly applying the same test, it's just that they happen to come to a different conclusion on the facts and the evidence and argument. My learned friend then made some comments on the Swiss decision, which is in bundle 3, at tab 37. In particular, in relation to page 1663. And I dealt with some of this in yesterday. In particular, he likes the suggestion on page 163 in the first paragraph that that if you apply a no reason to doubt test, the invention achieves technical effects speculative applications are not prevented. But then, of course, in the next paragraph, they go on to say that you need to meet the two criteria cumulatively, and that's how they, as we see in the third paragraph, how they reason that abusive speculative patenting is avoided. And then this morning, my learned friend made some submissions about in the second criteria at the end of the second paragraph. They say the skilled person must be able to deduce the technical effect is embodied in the invention. The second criteria is fulfilled if the technical effect is obvious to a skilled person, taking into account the general knowledge at the time of filing, and then the reference to the guiding principle where again it looks like they're using obvious in the way my lord suggested, not in a technical legal sense, but in a can you work it out? And in particular, then they also go on to approve the statements in 116 of 18, which is footnote 63, that experimental data or an express statement on the technical effect in the original application are not necessary for this purpose. And they make the comment that you mustn't set the bar too high. So this clearly is not a rejection of the judgments of the decision of the technical board in 116 of 18. They expressly refer to it, and we say are applying it, albeit they've expressed it in their own way. And finally, on the foreign authorities, the Norwegian decision that my learned friend likes, and this really is the high point of his case, that there's some support from national courts for him. And I can just pick up one point. So this is tab 39, and it's page 1734. And my learned friend started reading at the last paragraph, but if one looks at the paragraph above it, having reviewed the various authorities, the court says it appears that in practice the EPA seems to make a specific assessment of whether the technical effect is sufficiently substantiated. The EPA has not set out general requirements that experimental test data must be included, only where there is doubt based on the application as to whether the invention has the technical effect cited. Such evidence seems to have been considered necessary. So when
then you have to read on to the end of the paragraph. However, the condition for being able to take such subsequent evidence technical effect seems to be consistently the technical effect claimed had been sufficiently plausible.
Sufficiently, yes, my lord. But it's the doubt part, my lord, that they recognise that it's only whether there's doubt it's achieved. And so when they come to say that the enlarged board in G2 of 21 hasn't lowered the threshold, one's got to read that in the context of the previous paragraph. So this is it's a little bit of a mixed bag of a decision. And of course, my lord, this is one of the ones that we put into the category of, we've put before the court for completeness, because it's not the easiest decision to understand. But even if one reads it the way my learned friend does, he's still in the position where the majority of the national court authorities applying G2 of 21 are against it, and he's got one.
What about on the opposing page, at the second hole punch just above it? The decisive factor for whether technical computers problem in the assessment of event is whether at the time of the application, based on the BMS application in combination with the general subject knowledge, it appeared credible, i.e. plausible, to the expert team that this effect would be achieved.
Yes, well, that's clearly in my learned friend's favour. But the only point I was making was that they start off with the EPO position being the other way around. So this is a slightly mixed bag of a decision.
Right.
And it's a single decision. So then turning to the application of the test on the facts of this case. So can we take the core bundle out first and go to the grounds of appeal? And the learned friend, for the first time today, he didn't take this point in his skeleton, suggested that the challenge to the judge's finding that there was a reason to doubt based upon the Tanabe work wasn't part of the grounds of appeal. And so it's paragraph 17 on page 18. And it's the last sentence. For that reason, the judge was wrong to take them into account in assessing the plausibility of the patent, and wrong in the final sentence of 251 to find that they would give the skill team reason to doubt whether dapagliflozin would be an SGLT2 inhibitor. And so that last clause of the grounds of appeal, we say, is wide enough to allow us to challenge the basis of the judge's finding as a matter of evidence. Now, as to this, a really important point from the laws to keep in mind is my learned friend's own experts didn't support this part of the case. Their evidence was that the Tanabe compounds merely didn't inform. As I come on to, that ultimately is where Professor Potter ended up as well. And I showed your lordships part of the evidence, but perhaps I can just show you another part of that just to make it clear. So supplemental bundle tab 10 and page 204. So this is my learned friend's medicinal chemist, Dr. Edwards. He'd done his own literature search, which wasn't based on what was in the patent or the prior art, it was his own literature search. And he had found some of the Tanabe papers. We see in paragraph 3, apart from fluorescein, only one compound had been identified, T1095, and he refers to a paper by someone called Oku. And then he sets out a diagram comparing fluorescein and that molecule, which is the one that the judge put in the judgment. And then he identifies the structural similarities and differences between structure 1B of 128, which of course dapagliflozin falls within, and those are the points that my learned friend relies upon. And then in 6, he says, consequently, I do not think the skilled medicinal chemist would learn anything from T1095 that could be transferred to the most preferred compounds of Marku structure 1B in 1028. So that's him saying it just doesn't inform. He didn't go further and say, and what's more, it would give you reasons to think that it wouldn't be active. It's just not informative. So that was his evidence. And then my learned friend, as we my lords will have by now, went through the various papers referred to in W0128 prior art and sought to first of all confirm that it's not informative, and then secondly go further. And I showed you the sort of concluding part of the cross-examination. My learned friend took you through a few islands along the way, but what is clear from Professor Potter in his answers to those was that he was clear that it was generalising out was not something that could easily be done. So can I just show your lordship a couple of the passages? So it's tab 15. At page 253 of the bundle, 328 of the transcript. My learned friend says at line 15, what the abstract is teaching is there's a strict structural requirement for activity. That seems to be correct. So the medicinal chemist reading this is learning if you want to maintain SGLT activity, you're restricted to what you can do with the fluorescein structure. And the answer is that's just one aspect of modifying the fluorescein structure. I'm not sure he would be so generous. So again, the key point is that the professor's emphasising that it's changing the fluorescein structure, which of course is different to the patent, the one in both dapagliflozin and the patent structures. Then in 332, over the page on bundle page 254, my learned friend is asking about the ketone group. And at line 14 he says, but teaching that ketone is necessary is right, is it not? He says, in this sense, crudely speaking, the result is fine. Actually extrapolating to the reasons is a different matter. So he says that the result is what it is, but the reasons for the result is a different matter. And then over to internal page 339. At line 6, my friend says, the medicinal chemist is again being taught by the Tanabe group that if you move away from fluorescein at your peril, and they answer again with the caveat that some of these changes in a difficult structure that do not explain why you have the effect you are seeing. Replace X by Y and you get an effect. There's no wider context to see that. And then finally, before we go to the final wrapping up, in 343, at line 16, my learned friend said, what I suggest to you, Professor, is on the basis of what the skilled person will understand from the Tanabe work, they'd have no confidence whatsoever that something falling within structure 1 would have any SGLT activity based upon fluorescein or 1095. I do not see why not. We've been through the significant differences. Structure 1 has A could be a long linker with a mimic of fluorescein as well. Question, so it depends on whether it's similar to fluorescein or not. Is that what you're saying? You are saying it's not similar. I am saying you cannot assume that. Structure 1 is a huge Marcouche of many, many compounds. It could provide a molecule which would look ostensibly like fluorescein, 2 hours and a linker. And then in the next page, so you accept, Professor, based upon the Tanabe work, the skilled person want to stick as closely to fluorescein. No, I do not. Fluorescein is a complex natural product with lots of things wrong with it. The medicinal chemist aches for simplicity. Starting with a natural product, you have somewhere to go. Fluorescein is a natural product, and you mitigate those bad things using a combination of serendipity, intellect, and experimentation. So the professor was clear that the differences were relevant to the fluorescein structure. Generalizing was harder, and therefore when my learned friend came back at page 357 to 359 to put the actual question to the witness, which is 358 line 8, the reason for significant doubts, the professor pushed back at that and said, no, absolutely not. It doesn't inform you positively or negatively. And there's nothing odd about that position from the professor, because it's exactly the same position that my learned friend's expert. And so there was no evidential basis for the conclusion that there was reason to doubt. My learned friend tried to suggest, well, it was just the judge looking at the papers himself, but of course that's not a proper thing for the judge to do. The judge can't subsume or apply his own chemistry knowledge to look at it. He has to be guided by the experts and what they said. So, well, that's that issue. Then on to, finally and briefly, technical contribution. My learned friend emphasised, and his case requires, his case is that unless there's an advantage of the later patent over the disclosure of the earlier generic class, there is no scope for an invention. And we say not so. The key, what the authorities make clear, is the key issue is whether the later patent makes a technical advance, not whether it provides an advantage over it. And that depends on the nature of the prior art and what that teaches the skilled person. And where...
So the proposition is you can have a technical advance with no advantage.
Well, my lord, no, that's... perhaps it was the way I expressed it, maybe, to that. What I mean, my lord, is where the prior art discloses a class of compounds where the skilled person looking at it would say either, I don't know which of these, don't know whether any of these work, or I know some of them may, but many others won't, and I don't know which ones will work and which ones won't work. In those circumstances, in our submission, there is a technical advance in identifying the ones that work. Because as Dr. Edwards explained in his cross-examination that I showed my lords yesterday, from W0128, the skilled person would have to do SAR work to work out which of the other compounds were active or not. So this is not a situation where one can say, well, I think all of them were active. The evidence was that the skilled person would think that some would be, but others wouldn't, and had no guidance where to go. And in those circumstances, identifying one that actually has the properties is a technical advance. And that's why the nature of the prior art is an important part of the overall analysis, and that we say the judge didn't do. My other friend made a point about the decision in the Pixaban decision and said there was some difference because there were different classes of compounds. Well, I don't understand that submission. In the Pixaban case, the Pixaban itself fell within one of the generic class disclosures in the prior art. And in this case, dapagliflozin falls within the generic class disclosures of the prior art. So one can't put a cigarette paper between the two cases on that basis. So, my lords, unless I can assist you any further, those are my solutions.
Thank you very much, Mr. Yes, well, thank you all for your arguments and also for the efficient way in which this appeal has been prepared in short order. We will inevitably reserve our decision. And what I'm now about to say will explain how we see the matter going forward, as you have to make some practical arrangements ahead of the hearing on the 16th of July. I'll give you both an opportunity to make any other suggestions once I've told you what we intend. We hope that it will be possible for us to give our decision with reasons by the time of the hearing on the 16th of July, in a manner, and we would do so in a manner which would preserve the current position until the end of that hearing. For your comment, our intentions in relation to the process are these. Firstly, that by this time next week, we would invite you to make submissions, preferably joint submissions, including others who are interested parties in the matter, about the distribution of draft judgments in terms of who the recipients should be, what the distribution list should be, and what the terms of the distribution should be. So that discussion will obviously have to take into account the interested parties in the injunction matters and also government legal department. So could we invite you please to do your best to reach an agreed position as to what the sensible way forward is there. You will receive from us, we hope, draft judgments a number of days before the 16th of July. Those draft judgments will have the usual warning, which in this case is of real importance. The court, as almost all of you will know, distributes draft judgments in order that the handing down process can take place efficiently and as correctly as possible. The court obviously benefits from your assistance in relation to any typos or errors of fact falling short of re-argument. But the drafts must absolutely not be distributed beyond the distribution list, and I'm not only required, but I do formally and openly say that if in this case there was any breach of the undertakings that will be given in making the distribution list, we would treat them very seriously indeed. They would most likely amount to a contempt of court, and they'd most likely be dealt with as such. So could you all please, as I know you will, approach the process of handling the draft judgments in the way that complies with the directions that will appear at the top. When you receive that, you will be told when we invite your corrections and comments, and a draft order reflecting the decision. Insofar as you can't agree the draft order, short, focused submissions on matters of disagreement. Also, any submissions in respect of any ongoing application to the Supreme Court should be made at that point in time, and so before the next hearing. The hearing on the 16th of July will be before a constitution which is similar but not identical to this constitution, but as it's deciding a separate matter, that's not of any significance. This constitution will decide the appeal. The next constitution will deal with what the hearing has been set up for, which is to deal with the question of whether there should be any ongoing injunctions. You will have followed from what I've said so far that the existing injunctions will continue until the end of that hearing, so everybody knows where they stand. I think that from me, that's a statement of how we propose to proceed, but if there are any matters of alteration or improvement that occur to either of you, I'd be glad to hear them.
Yes, my Lord, my junior reminds me that we may formally need a slight carve out from the embargo to allow us, the lawyers, although it won't be me personally, to prepare for the hearing, because the rubric on the embargo only allows to be used to provide.
Yes, well, the purpose of us giving you a week from now is to think about things like that, and so you can, if there are any particular requests that you have to make, and particularly if they're unopposed, then we'll give them fair hearing.
Just to elaborate on that, clearly you will need to do what is necessary to prepare for the hearing on the 16th July. The question is, how far do you need to distribute in order to do that? What is necessary for that?
Yes. I mean, the essential components of all of this are always who are the named individuals who will receive the draft judgments, and for what purpose. So once we have the list, and everybody on the list knows or has been told, and it maybe has signed a statement that they've understood why they're getting the draft judgment, then matters go ahead in that way. Now, I'll ask you one by one, if I may, for any suggestions. Were there any other matters that you'd like to raise in terms of process?
I'm told no at this stage. No.
Yes, Mr.
Well, I find myself in slight difficulty because I'm not instructed at all in relation to any of the interim relief, because I'm representing all the generics. I can't act commercial rivals when it comes to. So I'm not up to speed with the issues that have been, I'm told, have arisen very recently.
Well, is that a very good reason why we should have a week to...
I'm sure it is, but I just, in terms of structures and responding to your Lordship's request, any comments today about what your Lordship just said, I just need to take instructions.
Well, in that case, would it...
And Miss Pickard, I think, can speak if that's permissible.
Well, I was going to say that, bearing in mind that difficulty, perhaps if there were any, as it were, structural changes to this, we should hear about them by perhaps this time tomorrow. So you have an opportunity to take stock.
I'm grateful.
And to think about the matter more generally, and similarly you do. But if you're both content at the moment that that's the best that we can do so far, then I suggest we proceed in that way. Yes, Ms. Pickard.
My Lords, just very, very quickly, I think from what I understand, one issue that is between us is nothing as to what you've indicated just now, but does relate to the timing for evidence for the 16th of July. Astrazeneca served an application notice this morning and are asking until the 4th of July for evidence in support of that application. On our side of the court, and I appear for Glenmark, I understand this is a common position. We are suggesting that evidence should go in as soon as possible, and at any event by the latest by the 30th of June.
All right. Well, I think that what we'll do in that case is have a separate work stream which will relate to issues relating to the question of the filing of evidence in regard to the injunctions, to issues relating to liaison with parties who are not formally represented before us today, and so forth. And I would suggest, subject to his being content with this, Lord Justice Arnold continues to case manage that matter, and that between you and him, you arrive at a time by which any submissions about those matters are heard, because those obviously can't wait for a week to be decided. So what do you suggest should be the length of time before a programme is sorted out for that?
Well, my Lord, I think we could in very short order put in submissions on that in writing.
Yes, we'll try and reach agreement first, and if you can't, then clearly a case management direction will be required quickly.
I'm obliged to read.
Right. Well, that is then an additional limb to what we've been discussing. Is that all right?
Yes, ma'am. Thank you.
Good. Yes. Now, is there anything else?
Well, I apologise for doing this, but there's a concern behind me. I know when my Lord said that the injunction will last until the end of the hearing on the 16th of July.
Yes.
There was a concern behind me that on the transcript it had appeared until the beginning of the hearing. I just wanted to make sure.
Well, I've been. I mean, I know that it's an extremely clever piece of technology, the transcribing system. I've noticed as we've been going along that there have been inaccuracies in it, which nobody bears any blame for at all. And so I will restate, in the hope that it comes up on the transcript this time, that the injunctions, such as they are at the moment, will continue until the end of the hearing on the 16th of July. So if that escaped. Could I also add, not because, frankly, we care very much, but it's important that the transcripts are as accurate as possible. And because we've been noticing that the microphones, for some reason, are not picking up any distinction between my lord on my left and myself, could somebody please be deputed for the happy task of checking judicial interventions against the YouTube in order to make sure that the correct judge is identified in case one day it should ever matter.
We will, my lord.
Is there anything else?
My lord, only on this side of the court, I'm
Yes.
sure, shared to gratitude the speed at which the hearing has come on, given the commercial situation, and we're very grateful to the court and those behind.
We've been able to all work around it, and it's a very good example. Thank you all.
Well, I